new Bharatiya Nyaya Sanhita, the statutory baseline is strictly drawn. Section 2, subsection 24 states explicitly that an offense means a thing made punishable by this Sanhita. Yet beneath that clean statutory text lies a paradox. Even after centuries of common law and millions of pages of legal scholarship, jurists still struggle to articulate a universal, substantive definition of what actually constitutes a crime. The difficulty exists because a crime is not an absolute, objective truth. It is a fluid, socio-political construct. The exact parameters of illegal conduct shift according to the specific policies and power structures of the state. For anyone preparing for the bench, rote memorization of the BNS is insufficient. A judge must evaluate the underlying socio-political elements that grant the state its authority to criminalize human behavior in the first place. This requires mapping the boundaries between private morality and public law, analyzing the specific social interests the state chooses to protect, tracing the constitutional monopoly on prosecution, and breaking down the strict anatomical elements of an offense. Mastering the exact wording of the BNS tells you the what, understanding the jurisprudence of criminalization reveals the why, and that distinction determines how the law is applied in practice. While many assume the law simply enforces ethics, criminal law and morality operate in distinct orbits. There is a common ground. For acts like murder, rape, or robbery, public morality and criminal law perfectly align. The state punishes what the community already finds reprehensible. But look at the territory outside the intersection. Extreme acts of ingratitude, avarice, or deep hard-heartedness attract intense social disgust, yet they completely evade the criminal code. The original drafters of the Penal Code illustrated this with a specific scenario. A wealthy man sees his neighbor starving to death. He refuses to hand over a single mouthful of rice to save him. The man commits a severe ethical failure, yet incurs zero criminal liability. Conversely, if the starving neighbor breaks into the house and snatches that exact same rice to survive, the state will prosecute him for theft. The law punishes the desperate man while ignoring the objectively cruel one. Or consider a highly capable swimmer standing safely on the shore, callously watching a child drown without intervening. Despite the universal moral outrage that triggers, the swimmer is not a criminal. The law governs specific prohibited overt acts and legal duties, not the individual excellence of a citizen's character. The drafters were explicit. A penal code is not a body of ethics, and the legislature cannot punish acts merely because they are immoral. Because the state refuses to punish all moral sins, a different utilitarian catalyst must exist to force the state to transform a specific behavior into a crime. That catalyst is protection. The state criminalizes conduct specifically to shield targeted social interests from harm. This infographic outlines Roscoe Pound's classification of these interests. It serves as the sociological blueprint for modern penal codes. The interest in general security drives the state to prohibit acts of theft, dacoity, and assault, protecting the physical safety and property of the community. Moving down the chart, the interest in social institutions forms the basis for laws against treason or bigamy, protecting the structural stability of the government and the family unit. If the primary goal is to protect interests, what prevents the legislature from overreaching and throwing the weight of the penal code at minor, non-serious wrongs? Legal scholar Andrew Ashworth's core principles of criminal law act as the necessary legislative brake on state power. Ashworth insists that the labeling and punishment of the criminal law must only be deployed to censure substantial wrongdoing. The law avoids penalizing behavior that does no actual harm to others. An act becomes a crime because it presents a substantial threat to the specific interests a society requires to physically and structurally survive. Beyond social theory, the truest test of an offense lies in its procedure. You identify a crime by looking at how it is prosecuted. Sir William Blackstone originally defined crime as a violation of public rights. That definition is flawed. Corporate directors can act with gross negligence and devastate a community's finances, yet their actions remain strictly civil wrongs, not crimes. This flowchart illustrates the procedural framework developed by Austin and Kenny. The true distinction between a civil wrong and a crime is determined entirely by who controls the legal procedure. On the civil branch, the victim controls the grievance. They hold the power to demand financial compensation, settle out of court, or forgive the wrongdoer entirely. On the criminal branch, once an act is formally classified as an offense, the state assumes the role of the victim. The proceedings aim for punishment, and private individuals lose the power to remit that penalty. This procedural theory is explicitly wired into the modern statutory application of the Indian Constitution. This schematic maps the exclusive power of pardon granted to the president under Article 72 and the governor under Article 161. These provisions prove that the state alone owns the criminal grievance. As Ward Atkin ruled, the common nature possessed by all crimes is that they are prohibited by the state, and that the state punishes perpetrators. An offense is ultimately defined by the state's absolute monopoly over its prosecution, its sanction, and its forgiveness. For a judicial aspirant, abstract theory must translate into an operational checklist. To analyze any charge under the BNS, we apply Jerome Hall's 7 distinct elements of a crime. Element 1. There must be external harm to a legally recognized social interest. Element 2. That specific harm must be explicitly prohibited by current penal law. Element 3. There must be a voluntary act or omission, defined as conduct. Element 4. There must be mens rea, the specific criminal intent or recklessness. Element 5. There must be a strict concurrence in time between the mind and the act. Element 6. There must be a direct causal relation linking the conduct to the harm. Element 7. There must be a legally prescribed punishment ready to be enforced by the state. Section 2, subsection 24 of the BNS is the surface. These 7 invisible pillars structurally hold every single criminal charge together in a court of law. Because crime is a construct of state policy designed to protect social interests, it must constantly shift and evolve. As economies transitioned from agrarian to digital, physical interference was no longer the sole threat. The concept of theft evolved into complex electronic fraud and white-collar crime. Advancements in medical science routinely forced the state to reconsider the boundary of harm, paving the way for the decriminalization of acts like euthanasia or assisted suicide in various jurisdictions. Effective judicial application of the Bharatiya Nyaya Sanhita depends on recognizing the fluid policy objectives behind each section. Every single provision in the new code should be viewed through the dual lenses of Roscoe Pound's Social Interests and Jerome Hall's 7 structural elements. As future officers of the court, you will serve as the administrators of the sovereign's exclusive power to punish. Crime is the ever-changing reflection of a society's values. The judiciary serves as the rigorous final interpreter of that boundary.